are here. We have missed 2 meetings because of the inability to get a quorum. Find a little bit worrying because it's a very important bill we're trying to settle. But we'll proceed this morning. I noticed there's nobody from the JSC here. We actually stopped at page 17, if I recall correctly. There are no amendments. Section 17, trial procedure. No amendments. Right. Any comments from my technical team? I will thank Mr. Golding and Senator Morrison. They have been the very faithful members of this committee. We can't clone it, but we'll have to find 2 members like them. They have been as good as the technical officers in attending. So, number 17, section 17, no amendments.
Oh, this is where we're starting.
Oh yes, that's jurisdiction of the circuit court.
So, Member Morrison was reading it last time. I don't know if you want her to read it.
Yeah, that's a good idea. When I read I read section 17.
Okay.
We're reading that. I'll read the section and then invite someone else to help me through. The jurisdiction of a circuit court to hear and determine offences under this act shall be exercised by a judge sitting without a jury, and there shall be no preliminary examination or committal proceedings. The committee noted a proposal from the Norman Manley Law School and the mode of trial with proposal for a panel of 3 or more judges to preside over at each hearing rather than having a jury at trial. We know that currently this is not contemplated in the court system, and in any case there would be a resource issue. The committee did not accept that recommendation. 17.2, in the interest of administration of justice, public safety, public order, or public morality, a court hearing a case in the exercise of its jurisdiction under this act may direct that A to C. Your committee notes that proposal from the ministry that section 17.2 be amended to include provisions for the protection of surveillance officers during operations or investigations. The committee did not accept the recommendation, but recommend that consideration be given to introducing new comprehensive surveillance legislation to include a menu of powers and investigative tools available to security forces.
A deals with identity of the person to be protected. B speaks about name, identity, address, witness, and such other particulars should be kept confidential and not be published. And then C says no particulars of the trial other than the name of the accused, the offense charge, and the verdict and sentence shall be published. But when the chairman reads further, you'll see that there is some discussion about witness anonymity, and then I guess after that there could be a discussion, because I think legal reform has comments on witness anonymity, and we do as well. But just to ask, what's highlighted here on page 17, that the committee did not accept the recommendation but recommends consideration be given. Is that a decision or is that a decision?
So suggesting new legislation rather than amending the Anti-Gang Act.
The reason I ask, because I do recall that there was discussion about some of these matters being able to be done administratively. And so when we talk about considering new comprehensive legislation, I'm not sure what we're talking about would be included in this legislation. And I remember, though, quite a lot of discussion, especially even from Member Golding, about the administrative techniques and tools, things that you can, implement administratively. So.
The agreement was that, yes, enough tools are available administratively in surveillance and protection of it, yeah. think this could actually be deleted because I think comprehensive legislation may go in a different direction you're looking at, not relating to this. We could find administrative tools to protect the witnesses and others in this case. If we need to expand, we may need to in fact put in some level of, literally we may need an intelligence act at some point.
Yeah, I mean, one proposal that had been put forward in our discussions was the idea of where we have different surveillance tools that under different laws that require different procedures to be utilized, such as interception of communications, access to financial data, bank account information, and so on, and even knowledge as to whether somebody is leaving or entering the country, whether there couldn't be one comprehensive order that the court can make on application that would enable the investigators to access all of that rather than have to go through all these different. It would be like a menu of things that would be available through one application, just to make it easier for investigations to be done in cases under this act, or it might not limit it to this act. It might be under it might be under a number of different statutes where you're dealing with organized crime and the type of activities that organized criminals get involved in.
I want to put this in the decision to proceed to that kind of legislation. It could be, if it's reworded.
The Attorney General had a view on it at the time. She's not here today, so I don't know what her response would have been, but it seemed to me that this would be a useful recommendation coming out of the committee, that that be something that is explored as a way to facilitate easier access to these strategic tools that the law does allow for, but allows us through a variety of different procedures.
We take the recommendation to be examined fairly quickly to expand those fetal legislation, which is what members are suggesting, that the recommendation would be to try.
So not quite introducing new comprehensive legislation, but it's more like amending what we have.
Following on from my learned friend and from what Member Golding has said, that it would be, I will agree with Member Golding that it would be very useful to explore. I think part of the problem that has probably dogged some of these investigative agencies is the fact that the various powers are in lots of different bits of legislation, and perhaps one of the solutions could be an administrative one where there is some standard operating manual, for example, where there's guidance that these powers are available, these orders are available, and how to go about them, rather than legislation. But that is something I think that is worth exploring. It may be that what could be required at the end of that examination is some way to consolidate these powers. But I think I agree that it would be worth exploring this.
So we need to reword the sentence then, I'd expect.
Yeah, if we want to capture that idea, I think it does need rewording. I'm not going to attempt to reword it though, but it needs to be. It does need to be reworded. I'm sure the technical team.
No, to come back to it, we must. Someone that's going to design a sentence would examine the development of a.
Explore a way in which the available surveillance techniques, both legislative and administrative,
could be brought together,
be consolidated into one process, whether it be an administrative process or maybe possibly a legislative initiative.
The appropriate wording. All right. The committee knows the proposal from the ministry regarding immunity for those who come forward to provide information. We know that there are two issues. A, plea bargaining was relevant to the person who came forward with information, and B, those persons performing functions in relation to surveillance officers would not be liable to any civil action. The committee did not accept the recommendations. What is the problem with plea bargaining again? If I recall.
I'm not sure how plea bargaining comes into this discussion. The discussion is dealing with immunity for persons who are engaged in surveillance. And I don't think the committee felt that that was something worth pursuing in this exercise. I don't know whether in the look at the surveillance tools that we have and so on, whether there is any need for that to be considered, but it wasn't a persuasive case that was put forward, I think, at the time, that if somebody commits something which causes loss or damage to somebody, that they should be immune because they're undergoing a surveillance exercise. I'm not sure where the plea bargaining comes into this. One thing we note is that there has been a successful prosecution utilizing plea bargaining. So we have two systems really. We have a guilty plea system, which is quite popular and is helping with the backlog situation in the courts, which is underpinned by legislation and is utilized. It's fairly commonplace now. And then we have the plea bargaining legislation, which is newer, and this I think is the first sort of high-profile example of it being used successfully, that I'm aware of anyway.
This is looking at immunity, but there's current plea bargaining legislation allows for some level of reduction or even lack of prosecution. I'm not sure. The A here doesn't see anyone who recall why this fits in here. Mr. Bailey, you're watching this. I don't see how A fits into this. Right? Needed. Certainly those performing the function of surveillance officers not being liable to civil action. You don't need this now. What this was seeking to do is that, all right, then.
This was a proposal from the ministry, Minister, so perhaps they are better able to explain. But I think one of the things that did happen, though, is that there were lots of proposals that were made, which were made they're sought to put under this piece of legislation, which were not really appropriate for this act. So although I think maybe many of those proposals are valuable and have merit, they need to be elsewhere.
The ministry regarding the use of pseudonyms, undercover names that protect their identities for persons, including witnesses in court proceedings. But this is not yet established. It's coming. The anonymity of witnesses. Is that now being used?
There was some discussion, and we were asked to consider whether there could be like a one clause, a provision that could be put in I guess somewhere around the same section 17 of the Act to deal with witness anonymity. So we did a little research, and I would caution against it. There is no small one clause to deal with it. The jurisdictions that we looked at within the region and elsewhere have either an act by itself or several, like a part in a code. So it would be several provisions built into putting in safeguards. And we have to be extra careful because of section 16(6) of our Constitution that affords a person who has been charged with a criminal offense with certain rights, including to be entitled to examine or have examined at his trial witnesses against him, and to obtain the attendance and examination of witnesses on his behalf under the same conditions. Not to say then that you can't have it, but to ensure that we put in adequate safeguards so that we can meet the test. It's a one clause won't work, and we didn't find that in any jurisdiction. As I said, it's either an entire act or it's a part of a code where they have safeguards inbuilt to ensure that the right to a fair trial is protected.
The issue was that the issue brought by Mocha or whoever it was, their concern was what? That persons' names were being divulged during the trial or prior to? Or how, do you remember how they framed the problem?
But I see here the second sentence in this paragraph says, we were advised that such applications could be made prior to trial. I recall that there was discussion about what could happen prior to and during trial.
Is it something that we could facilitate by an enabling provision to make regulations to address? Because if we don't have a comprehensive witness anonymity law, but it is needed. So I'm just raising whether, for example, it is something that could be done by way of regulations under, if not this legislation, maybe under the Criminal Justice Administration Act, perhaps, or so that this, you know, and it would be subject to affirmative resolution, so it would have to come to Parliament to be blessed, so to speak. But it might be a quicker process of developing it than to say we want to go the route of separate new witness anonymity legislation. I'm throwing this out as a thought.
Yeah. Chair, if I may.
Yes, is it that, so Mr. Chairman, is it that we're considering, it says here that your committee did not accept the recommendation, and the second paragraph that we're just looking at now, your committee recommends. We note the need to ensure the identity of witnesses in the relevant related cases. They just looking up, because I agree that in terms of, well, I'll rephrase it. An accused person has the right to know his or her, the person who's accused him or her. They have that right. So for us to be saying anything other than that, I don't think it would be fair, whether in law, in principle, or otherwise. It would erode every single thing to have a trial and the accused does not know the name or identity of the accuser. Because you have a right, if someone has said you has done something, you have a right to know who that person is. You have a right to look at that person. And remember the presumption, innocence until proven guilty. At no point in time must we ever seek to erode that presumption. So I completely get it. We do have a problem here and we have a problem there and we're trying to bring everything under control. But at the same time, notwithstanding whatever else is happening within the society, that presumption must be paramount. One, the presumption of innocence until proven otherwise. And two, the right of the accused to know who has in fact accused them. Because people will have motive all the time. Whether it is, I mean, you know, whatever reason. We had one case, Mr. Chairman, where the young lady, she said that she and the child's father, they were in a disagreement. And she just went to Sissoko and said, he raped me. And you know what happened after that? You know, he spends 2 weeks in custody. Nothing at all because there's a custody case. We had another situation where the landlord wanted to get the tenant out. And the next thing the landlord said, well, the tenant is involved in a gang and the tenant put a gun on me. And the 10 young man, again, he's in custody for once. So just to indicate that I think it is important that those principles are preserved and that in terms of this anonymity thing, I can understand with maybe statements prior to the trial, but certainly at trial you must know who has accused you so you can confront them and do your own research as well to see what the motive is or whether or not the person is telling the truth or not.
If I may, Chair. Yes, what Member Terrelong said is well taken, and this is why I think we on this side had concluded that a simple provision would not suffice. And research, or additional research has indicated that to be the case, that as the SG said, all safeguards would have to be built into this. The other side of the discussion would have to be what is also in the interest of justice, which is the similar situations to which other jurisdictions have grappled that have problems like ours. So that balance that has to be struck to ensure that the rights, both constitutional and common law, to be able to confront your accuser is preserved in a way that is not prejudicial. But these are things that would have to be built into any legislative mechanism to achieve this, which is why we're of the view that it would be a little more difficult than simply having regulations done under existing legislation as it stands. There was a proposal, some very extensive proposals from the DPP, and my understanding is that it is being, a cabinet submission is being prepared in relation to it. It was to deal with witness anonymity, a full suite of recommendations. I believe that is where it is at this point. That's information I hear, that it was, it came to the LRD, and we have supported all those recommendations, and it's with the Ministry of Justice.
So I look at that is to leave this as is and look forward to this suite of
we could as probably Minister just note that we are advised that the Ministry of Justice is pursuing comprehensive witness anonymity legislation, and the matter should soon go to cabinet to seek drafting instructions, permission to issue drafting instructions or something. So in other words, it's being dealt with.
Mr. Chairman, I would recommend also that, well, first of all, I have my own views on that, as I've already expressed. I think it'd be important to get the Bar Association, if such a move is being contemplated, that the Bar Association is advised that they can comment at it as well. And again, I must caution such legislature, simply because, I mean, having practiced at the bar for some, 19 years now. Well, not now because I'm here, but there are things that will happen in terms of travesty of justice, and we must always be mindful of the little boy and the little girl who, because of their civic address, certain allegations can be made just willy-nilly at times. So we must be careful of that. I mean, and they should have a right to know who's accusing them so that they can properly prepare their defense, because it does in fact go to the heart of an attorney and a client and an accused person preparing their defense in their matter, and they do have that presumption of innocence until a court says otherwise.
I think that's why the move is to have a comprehensive piece of legislation dealing with witness anonymity, and the Ministry of Justice is pursuing it, so we expect it to be brought here. Understand certainly what you're trying to, that we have to protect the rights of the individuals from, malicious or just willy-nilly accusation. But in the particular case we are looking at, we need witness anonymity. When gang cases are concerned, that's the reality of it, or we may never prosecute any of them. But it certainly could be taken as a minor amendment here. Same page 18. Yeah.
Right. Your committee notes a proposal from MOCA to empower the court in the course of a trial to protect the identity of persons, as well as to institute gagging orders, and that this be done through a mandatory application made by the Crown or initiated by the court. Your committee also notes that the applications could not be mandatory and assessments were made on a case-by-case basis, and the courts would need to be satisfied that it was in the interest of justice to grant the application requested. We believe that this is an internal matter for MOCA and the Director of Public Prosecutions to operationalize that these applications would be routinely done. Your committee did not accept the recommendation. 17.3, a person shall not publish any information in contravention of a direct order under subsection 2. Your committee notes there were no proposals for section 17.3. Section 17.4, a person who contravenes subsection 17.3 commits an offense that shall be liable A, on summary conviction in a resident magistrate's court to a fine not exceeding $1 million or imprisonment for a term not exceeding 12 months or both such fine and imprisonment, or B, on conviction or indictment in a circuit court to a fine or imprisonment for a term not exceeding 5 years or both such a fine and imprisonment. Your committee notes the proposal from the ministry that the fine in paragraph A be increased to $3 million and the custodial penalty increased to 3 years for the disclosure of information in contravention of a direction given under section 17.2 of the Act. Your committee decided to accept the recommendation to increase the fine to $3 million, but did not accept the recommendation to increase the term of imprisonment. Section 18. Power of Minister to amend first schedule and monetary penalties, first schedule. Your committee notes there were no proposals for Section 18. Section 19, Regulations. Your committee notes there were no proposals for Section 19. Section 20, Amendment of Enactments, third schedule. Your committee notes there were no proposals for Section 20. Proposals for new provision to be included in Act, new provisions to be included in Act, tipping off offense. Your committee notes the proposal from MOCA that there be specific recognition of an enhanced penalty for law enforcement personnel who are proven to be members of a criminal organization and or are actively committing the offenses prescribed in the Act. This is in relation to law enforcement personnel who tip off criminal organizations operating in particular communities, impeding law enforcement deployments, and who carry out extrajudicial killings, etc. Your committee accepts the proposals who hold high positions such as members of the political directorate, including members of parliament, the cabinet, mayors, as well as other categories of persons such as prosecutors and justices of the peace. We further recommend that there be a definition of political directorate to include cabinet members, members of parliament, senators, mayors and councillors, as well as other categories of persons with authority, such as justices of the peace. We advise that the basis for these recommendations is the fact that it is insidious that there are persons responsible for the enforcement of the law and for making the laws in the country who are involved in gang activities and fundamentally undermine the rule of law in the country. We agree that a clear, unequivocal message must be sent in establishing and enforcing the law.
Could we just stop there and just discuss this? Chairman, just a couple of things. So what this seems to be saying is that for law enforcement personnel who commit an offense under the Anti-Gang Act, their status as being law enforcement officers would be an aggravating factor in sentencing. That's what I read A to say, although the word who I think is missing before the word are in the second line of A. B now seems to be a substantive offense that is being proposed of tipping off criminal organizations, which I have no problem with, but I'm just wondering why it shouldn't just apply to everybody. In other words, why carve out politicians and others? I mean, why does anybody who tips off gangs that there's a pending law enforcement operation, that should be an offense. There should be an offense of tipping off, if there isn't one already. Yeah. I don't see the need to get into contentious, groups of persons and all of that. I think it should be across the board. Tipping off is an offense under POCA already in relation to money laundering investigations. I don't see why it shouldn't be one here.
Recommendation here.
Chair, I think in relation to what Member Golding is saying, the basis for adding these persons, I'm looking back here, is that it was considered that insidious that there are persons responsible for law enforcement. So I guess the whole idea is that we are, as individuals who are responsible for law enforcement, to be caught in that should be, that was my understanding.
That would keep it confined to law enforcement personnel.
Yes.
Yeah. Because the others who are here are really not directly involved in law enforcement. And if tipping off in those contexts for anybody is there another, well, putting them in here does stretching it a bit, but if somebody gives information to a criminal, isn't that an illegal act? Yes.
Chairman, I think Mark has a very good point. Let tipping off increase the penalty, make it aggravated for all persons who tip off. And the judge would use his or her good sense to say, if the position is a person in authority, a policeman, a politician, or a pastor who does that sort of tipping off, then the judge would use his or her discretion to impose a higher sentence. So just make it a significant penalty for tipping off.
In other words, rather than naming anybody here, just any concern with that?
Is tipping off currently an offense in the Act? No. So we'd be adding a new offense to the Act of tipping off.
It's proposed an offense.
Is it proposed to limit it to gang-related offenses, or should tipping off become an offense?
No.
In relation to any serious offense?
No, hold a minute. If you go into any serious offense, can it come under this Act?
It could be done by way of a consequential amendment coming out of the amendments that we're doing. This could be one of them. We can recommend it as a consequential amendment to other acts.
Let me get a structured law. So it would become an offense under anti-gang legislation now, suppression of crime. But it should have consequential amendments in all other. If you make tipping off an offense.
No, we wouldn't need. If we do a general offense of making it illegal to tip off criminals or of law enforcement action that's being planned or implemented, if that could be put in a statute. I'm not sure which, but the right one. Maybe the Constabulary Force Act, I don't know. And it would apply to any serious offense. It would apply to gangs. It would apply to drugs. It would apply to sexual offense. It would apply to everything. So it wouldn't be an amendment to this Act. It would be an amendment to the Act where the general offense is being inserted.
Would that fall now? I mean, I need to get this somehow. That tipping off. So in the current Act we have before, it would make tipping off an aggravated factor. But you want a general offense for tipping off elsewhere.
I don't think tipping off is a aggravating factor. I think tipping off is an offense which needs to be criminalized. It's already criminalized in relation to money laundering, but it's not. I'm not aware of it being a general offense.
What you're suggesting that we should make that general offense.
Correct.
And it would not be under this piece of legislation.
It wouldn't be under this.
It would be a consequential amendment to another piece of legislation based on the recommendation here.
Right. But it would apply if you did a tip-off in an anti-gang situation. It would apply to that as well. So it would apply to all serious offenses.
Then how long would that take to get that done, and what the legislation would be amended?
They may want to think about it. I just throw out the Constabulary Force Act because it's a general statute involving police powers. That might not be the right place for it, but yeah, they may want to think about that.
Yes, Chair. We will have some thought about that.
We are past that, you know, what the suggestion I think make a lot of sense, that you already have the process of crime, rather than have another piece of legislation. Indicate here that tipping off, you know, is being criminalized. Where do I put that, if not in this legislation? I'm asking. Where is the consequential amendment?
And the way it's dealt with in the Process of Crime Act is really tailored for that type of activity, you know,
yeah,
like
I understand that.
Yeah. So I think it should be somewhere else, but yeah.
But I think we need it quickly. So I'm trying to figure out where would we, and we'd have to make a recommendation as to what legislation we're going to amend and proceed to do it.
Yeah, well, at this point, Chair, I mean, the JSF Act is a possibility, also the Criminal Justice Administration Act, since this sort of seems to relate to a obstruction of justice type of criminal justice offense. So those are possibilities, but we can give answer that.
Clear, we agree that the recommendation of tipping off be an offense, then we could not only put it as a part of this act, but in a general criminal justice act, we include it at some time, and the JCF Act. Because tipping off is a major
I'm
problem.
pausing here that I need to clarify it.
Yes.
Now, you're recommending we still have it in here as an offense?
No, you don't need it in here.
No, I didn't get to what you're saying, Minister, because the impression I'm getting is that we should just take a decision that it must be criminalized, and we look for the appropriate piece of legislation to make the amendment to.
So with the JCF,
Is that there?
Justice Administration Act.
It wouldn't hurt putting it in. It wouldn't hurt putting it in everyone to emphasize it.
I think the point that was being made by Member Golding, that is that quite apart from this particular statute, that it is and I think everybody's agreed that it's a general offense that is problematic for just about all serious criminal offenses. So it would be good to have a provision that covers that generally, and there'll be no harm in having a specific provision in this statute, as similar to what is in poker in relation to tipping off for offenses under this act.
I'm trying to get the process clear in my mind as a layman. So we'll have included in our anti-gang and our amendment which indicates that tipping off is criminalized for these purposes. Would also indicate a decision that we think tipping off should be an offense generally, and find the appropriate legislation to amend accordingly, whether the JCF Act or the Criminal Justice Administration. Okay?
Chair, agreed, but I don't think that the committee needs to get into the specifics of identifying the piece. It could just be a recommendation going forward that a general offense be created. But Chair, the issue of singling out the law enforcement officers and these other persons referred to, that came in the context of discussing some aggravated penalties. That was where that came in. So I don't know if the committee wants to consider that.
I like the idea of increase the penalty, because while I can see need to come hard at individuals who have responsibility, where tipping off is concerned in gangs, anybody who's involved in it the fine should be a deterrence. I mean, for public officers, in addition to fine, anyway, they'll have reputation matter, which would be that's itself a danger. So
you make the penalty sufficiently grave that, I mean, if it is a minor tipping off at a low level, the judge will know how to deal with it. If it is a politician tipping off at a gang, then it's a higher penalty, as the case may be.
Unless this is large brother.
Well, we may not know.
Sorry, just to be clear on this. So if we created a general offense of tipping off, we could say that in relation to sentencing, it is an aggravating feature if the person convicted of tipping off is somebody who's in a particular position in relation to the state, law enforcement, legislative, or so on, you know, some kind, however you define it. Now, are we not in favor of that? Or is that, I was trying to, I'm not sure what the
I think
feeling, the leaning of the committee is.
a higher fine, that's a deterrence in it, and give the judge some discretion in the process. That if someone has, like law enforcement person or legislative individual, without naming individuals categories, anyone who has privilege and power and use it to tip off, then the judge will have to use that in their sentencing.
And the aggravating element would be in the level of the fine, because presumably the offense would also carry a potential term of imprisonment. But you're suggesting that the aggravating feature should be limited to the fine rather than the term of imprisonment. That would be unusual. We don't normally, in my recollection, differentiate. If there's an aggravating feature in sentence, we don't differentiate whether it affects one element of or approach to the penalty as opposed to another. You know, it's just an aggravating feature that can result in a higher sentence or a higher fine or both. Sometimes, if it
leave that to the judiciary. All right. Comment, Mr. Richards.
So, Minister, I was just pointing out that the draft from CPC, in our discussions, the distinction was made in terms of the whether it's a law enforcement, member of judiciary, justice of the peace, or a member of parliament, correctional officer, and the distinction is in terms of the term of imprisonment, additional 10 years. That was what we accepted. Additional 10 years. Additional terms of imprisonment for 10 years. Right. In those categories, for those categories of persons.
You might want to say, if the penalty can be aggravated or an additional amount added if the person is in a position of authority or trust, as the case may be, rather than naming, you know, counselors, GPs, you know, then the category will never be closed. But because what would be wrong with adding teachers, pastors, you know, lawyers and.
Yeah, I think that in terms of what Member Golding has said, I mean, that pretty much sets us on the right path and allow for judicial discretion. I think too often we try to erode judicial discretion, and we must also remember that judicial discretion is a primary function of our constitutional democracy as well. And our judges are very intelligent, very astute. I mean, they will understand the case that's presented before that.
Now, all right, the decision then, we accept that tipping off should be included the anti-gang in the current legislation, but we recommend it become a general offense. In the case of anti-gang, you're suggesting that if the person is a position of trust, it's become an aggravating factor. And the judge will have to use that insensibly, use their discretion in sentencing the individual. Okay? Well, I hope they use the discretion.
Your committee notes the proposal of the Office of the DPP to include an offense of hindering, prejudicing investigations similar to Section 104(2)B of the Proceeds of Crime Act, and noted that under that legislation, the offense is limited to money laundering type offenses. The offense relates to falsifying, concealing, destroying, or otherwise disposing of, or causing or permitting the falsification, concealment, destruction, or disposal of documents that are relevant to a money laundering investigation. We accept the recommendation for a similar provision to Section 104(2)B of the Proceeds of Crime Act to be included in the Act but should be applicable to offenses under the Act and not money laundering offenses.
Any concerns there? We accept the basic principle of including a similar clause to 104(2)(b) of the Process Crime Act. Right? SC? Compelling a suspect with an electronic device to provide the police access.
Your committee notes the proposal from MOCA to compel a suspect in possession of an electronic device to provide the police access to the device in furtherance of an investigation. We note that this should not be limited to the anti-gang legislation, and to open a person's phone is similar to the need for a warrant in the same way to enter a person's house to investigate. We were advised that Section 17 of the Cyber Crimes Act already provides for a regime of such action and for disclosure under court order by a warrant. It was a provision of general application. Your committee did not accept the recommendation. Remember, Terry Long, I hear you saying.
Cyber crimes.
We're fine?
The recommendation as we have, this is a general requirement. I need a little bit more start. Yeah, I'm asking. Right. I remember the presentation here, but it's just that communication has moved so heavily to electronic media. This is like, it's not how you talk.
Chair, I think there was a very extensive discussion on this subject, and I think what we sought to point out is that I forget which part of it, but a part of the Cybercrime Act, the latter part of it is actually providing investigative tools for offenses where there is a computer, and that is defined as anything electronic that processes data, down to a thumb drive or anything of the sort.
So
that there are tools available.
The legislation covers this then?
It covers, yes.
So we have
And it is of general application. It simply gives the power to law enforcement to apply to the court for various sorts of orders, to access devices, access memory storage, access passwords, and so on.
You see, which reiterates or underscores the point that Mr. Bailey made earlier, which is a need for a kind of comprehensive administrative document that makes the investigators aware, or which they can easily refer to in relation to all the different tools that are there at their disposal, if they know where they are, where to look and how to use them, such as this.
I remember that being raised before. There's legislation out here that covers a lot of the things we're asking, which apparently investigators are not too aware of. So I think, come out of this discussion, we should in fact request, it will be DPP really, and agencies of government to provide, to develop this handbook, or whatever, what you're going to call it. What's the appropriate term, Mr. Bailey? Well, we need to get to the investigators. We need to get something to investigators that we have passed laws that allow them, even if we need to make amendments to make it more effective. But tools are there that they can use. It appears there's a lack of appreciation of the tools that are available. Who would be responsible to get this done?
Perhaps, Chair, there needs to be some considerations to how these sorts of legislative changes and new developments are communicated and proliferated through law enforcement.
Who would be the responsible individual? As a Minister of Justice, AGC, where do I go to? What I want to get of is to have a clear picture in my mind, because I think it is, where I'm coming from, Mr. B, I'm convinced it is necessary, because you have had a decline in the quality of our investigative units over the years. We are rebuilding it in the police force. Now they need to have all the information about the legislation we have and what can be used and how, and we are giving them lawyers, but I think that there still should be a document somewhere that provides, if not even a guide for investigation, a guide for training.
Well, my initial reaction, Minister, would be that this is perhaps something that could be led by the Ministry of National Security in collaboration with perhaps the Ministry of Justice, and would definitely have to involve leadership from the DPP also in relation to this, and perhaps something can be constructed to make this an ongoing process, so that this information and there's that kind of streamlining between the approaches and the procedures that the different agencies are using.
I appreciate it. And my director, I'm going to sit here, I'm going to actually make a note of that, because on several occasions raised in this room in this piece of legislation is lawyers pointing out that there are tools available that are equivalent to what we are asking for again. And, you know, over legislation is as bad as no legislation at all. So, well, not quite, but it is not in the best interest, best use of our time and our personnel and resources to be duplicating activities, and that too can lead to other problems.
I think your point is well taken, Chair, because I'm just recalling that several years ago in the review of the Cybercrimes Act, we had ended up having a very similar sort of discussion in that Joint Select Committee.
I will certainly make notes so that the Ministry of National Security can coordinate that development, because I think it's critical for the JSCF, and would of course bring the JSCF on board and the other relevant investigative agencies. So that that recommendation comes out of that recommendation, not legislative, but more administrative. Treatment of non-nationals.
Your committee notes a proposal from MOCA regarding the treatment of a non-national being considered a member of a gang. The rationale being that if said person came into the jurisdiction to be involved in gang activity, that ought to be treated as an aggravating factor when sentencing a person convicted of an offense under the Act. During the deliberations, it was raised that the offenses committed would have to be proven, but the point was to create a strong disincentive for foreign nationals to come to Jamaica and become involved in such activities. The prosecution would have to prove that the purpose for coming into Jamaica was to be involved in gang activity, and if the person came as a member of a gang, a citizen or not, he would be arrested, charged, and convicted under the Act. It was added that once he is an associate or member of a gang, his citizenship status would not matter. Your committee decided to accept the recommendation to the extent that a non-national, being a member of a gang, should be an aggravating factor.
An amendment that a foreigner caught here leading into a gang or engaging a gang, him get a longer sentence. That's what you're really saying. And be deported after that. Because remember, currently I have the right to deport him once a foreign national, almost by, am I right, SG? Almost by dictate. Once my passport and immigration service recommend it, I can deport him almost immediately.
Okay.
But the suggestion here is that if he's involved in gang activity, we can give him a harsh sentence and then we deport him. All right? I don't have a problem with that, because we are part of our gang problem that we are made a transshipment point, which means the critical player tends to be, that critical players tend to be non-Jamaicans. So if we catch him here, or you make it a disincentive for him to come here. All right.
Your committee notes the proposal for the power of search and seizure to determine whether there should be a default position which required having a search warrant and then examine the circumstances that may permit search without a warrant. Your committee did not accept the recommendation, but recommended that the issue of search and seizure be addressed as a consequential amendment to the Constabulary Force Act.
We get that clear again. So we are giving on the Constabulary Act, giving the police the right to search and seize in any as a general power, or do we want to do it on that?
No, what the committee had accepted, Chair, is that the power of search and seizure should be a general power and in the Constabulary Force Act, rather than limited to simply just this particular statute. We have given some consideration, and we are of the view now that quite apart from having a generalized power of search and seizure that can be put in the Constabulary Force Act to empower the police, that provision should also be included in this act as it stands. And the main reason for that is I think part of the difficulty that was being addressed by both the DPP and the law enforcement was the problems that they had now. That new police act is still, as I understand it, in development. So rather than wait until that eventually comes, and that provision could be in that statute, that the amendment is made now in this act and to await the more general provision.
I like that, sir. We'll proceed along those lines.
Your committee.
Just a question. So in the
Should be amended.
When just a question. When the other law comes in, is it that you're going to repeal this provision in here? Because it could be that they are not consistent. Because you may be going a little wider. So
Well, when that comes along,
this is a more temporary measure then?
I would be advised. I wouldn't put it. I'll just make the amendment, and when we get to the Police Act, if necessary, we'll examine this situation. I'll be advised by the team.
I kind of query the approach because, for instance, we haven't put it in every other law. And then I don't know if now there's going to be an issue with application of the powers in this compared to, say, I don't know if it is in the Lotto Scam Act. I still just kind of query the approach.
Well,
I know that this is being reviewed. I understand, and that you can still put it in. But yeah,
I hear your concern, SG, and I respect all it, but I think we need something of this sort because of the nature of the gangs and the way they operate. It's a question if it is in conflict with other legislation.
Sorry, I got distracted. Which point are we on? Search and seizure. I thought we were going to do that as a general power in the general statute.
The recommendation from you didn't hear Mr. Bailey, that he was pointing out that since the JSC Act is somewhere down the road, we should maybe include in this, and SG suggesting whether we are making it temporary or we just will re-examine this when we get the JSC Act in place.
You mean the police services law that you're coming with?
Yeah, which is a little way down the road because remember there's a constitutional aspect to it which will take at least itself, even if we get it
but,
laid.
You know, if it's done as a consequential amendment at the time that these amendments are being passed, and whatever bill is being prepared to amend the anti-gang law, we'll have a schedule to it, amending whatever the consequential amendments are. It don't take no more time than any other. It's just all going to be done at once. So the fact that you're reviewing and hoping to introduce comprehensive new police legislation, which is going to be a major undertaking, I don't think that should delay this.
So what are the details? What sort of search and seizure provisions is the committee asking for? Because remember, you have varied approaches,
including the one in the drug one, in the dangerous. Is it the dangerous?
And
drugs?
there is a more recent one that was done in the MOCA law a year ago, which also. The reason I'm asking because you have different provisions. Some that say you can enter with a warrant, some that say you can enter without a warrant. Sometimes the warrant can be issued by the Justice of the Peace or a parish court judge. So I'm saying there are different modalities, I don't know how to put it, and I think the committee should then consider what type of search and seizure provisions you would want included here. Since you're going to put something in, I think you need to give a little more guidance.
What was the DPP's recommendation? Because this kind of came out of their paper. Yeah.
That was what we've been operating with Member Bowling. The DPP made extensive recommendations, and the warrants would be on the basis of signed by a JP. And it's to, yes. So let's read out what the DPP had recommended.
Remember, Gordon was also suggesting that if you have a consequential amendment, it's to be done same time on the current JCF Act. Is that what I was getting? Rather than.
And I would imagine the new one, when
Yeah,
it
it
comes,
would come a new one, but-
the new one would just carry that forward. It would,
Yeah,
in other words, it would continue.
fair. No, I can see that. But I'm
Yeah.
just saying, what, how does that, is that in conflict with what you're suggesting? Because what is just the timing? If you can get it done now on the current JCF Act, or is it already included in there?
You see, Chair, given the critical nature of the problem we have with murders in the country, I don't think we should be delaying anything. I think what we can do now, we do now. Yeah. I mean, ideally, maybe it's not ideal because you have a police services act coming and that would be the time, but I think we should just do it now. And
I have to do it now. It's just what the best way to do it. I don't want to do it with any kind of.
Chair, my only caution with this is that as it stands now, we have several statutes that have search and seizure power. Some warrants are obtained under the signature of a JP, some under a parish court judge. And I think it would probably be best if we would sort out to streamline those issues rather than put this power with a JP into the Constabulary Force Act right now that may have issues in relation to those other statutes. So,
In other words,
that's my
let's
initial
put in this
concern.
act
Yes.
now
Yes.
with the JP as authorized during the sign of the warrant, right? As recommended by the DPP.
Yes.
And we'll look at the JCF Act when it comes along.
Or in the interim, we can proceed to look at putting this provision into the JCF Act, but we need to ensure that we're not creating other problems in
I
other
think
statutes.
on that note, we need it in this act, given the nature of the problem we have out there.
Chair, well, if it's inserted in the Constabulary Force Act now, we could just simply maybe exclude the application to acts that already have a provision for search and seizure.
CPC, could you just repeat that recommendation? Sorry.
I was saying if we were pursuing the option where we include the search and seizure power in the Constabulary Force Act now as a consequential amendment here, then we could just, so that we don't affect other laws that already have search and seizure provisions, we could just exclude the application on the Constabulary Force Act to laws that already have a search and seizure provision.
And the one that we would put in of general application for the laws that don't have it would be based on a JP issued warrant. Based on what the DPP has recommended then. Yeah. Since a decision has to be made, let's just make that decision.
Clearly the mic doesn't want me to belabor the point, but the DPP proposed JP specifically in relation to the anti-gang. Now, when we do it of more general application, we're looking at a variety of laws, and I'm wondering if the DPP's recommendation would still be warrant by JP across the board. I don't know if that is something that you would want to still consider, whether it should really be a JP, whether it should be a parish court judge, because we're looking at a wider scheme now and not just the anti-gang. I mean, you may decide that it's still appropriate for a JP, but I would just like the committee to at least just discuss it and take a decision.
I think we need on this one. So I think I'd want it included as a specific amendment in the anti-gang with a JP. Now, if you go to the General Act, then, but does it do any harm doing both?
I don't know.
Because what this CP is, or that when you go to the General Act, you exempt the act that's already in place with search and seizure with a particular warrant.
Chairman, are we going to have another meeting?
At least go through the document today.
Could you give us an opportunity just to give an idea of perhaps some of the other laws that currently don't have it now? So we kind of have an idea of which laws we would be impacting then.
Okay.
And then maybe it could give the committee a better idea as to whether you still want to go with a JP or no warrant or a magistrate, or a parish court judge.
Definitely warrant, Mr. Chairman, because you don't want this. You don't want a situation where people's doors are being kicked.
I'll go with it, but I'm going to call again. Make sure we have a quorum early January.
Yes.
Finish this document.
Yeah, I mean, just to indicate, but definitely warrant though.
No.
So you don't situation where people are kicking down people's doors.
Legal guidance.
Definitely warrant.
Forfeiture of assets upon conviction. They're going to leave it for them to research.
Your committee notes a proposal from MOCA to add forfeiture of assets upon conviction, as well as for the immediate cancellation of licenses or contracts awarded to accused persons by government agency or entity as a new provision in the anti-gang legislation. We did not accept the recommendation.
What page are you at?
21.
I turn to Mr. Bailey and Mr. What's the discussion on this topic now? Someone that rejected it outright. Is it a little bit? There's something to do with contracts and.
No. Next proposition.
I will recall rejected this totally. Sound a little bit funny. You have it.
I'll have to re-examine. So.
What did you have in the comments here? I find it a little bit. Mark, do you recall this one? Why did you reject this so outright?
We're on page 22.
Yeah, 21, the last item.
The
committee, the proposal from MOCA to add forfeiture of asset upon conviction as well as for the immediate cancellation of license or contracts awarded. Currently, forfeiture of assets, you have to go back to court. What's the current practice?
There is some legislation where asset forfeiture arises on conviction. You know, there's provisions in the Act that deals with it on conviction. Poker is one. I think also even the human trafficking may have it too, you know. Yeah, I'm not sure. Yeah. Poker's yeah. But on the other aspect of it, which is the cancellation of licenses and contracts, that I think is a bit of a potentially thorny issue legally because it may involve third-party rights. It may involve situations where gang leader A has equity directly or indirectly in company B that is getting all kind of quarrying work and construction where we don't know this is reality. But if leader A is convicted, you know, how do you address a company such as B where he may or she may not be, for one, they may not be on the record as a shareholder. They just have somebody fronting for them, and B, there may be other persons involved in the company, not just them, who are not convicted. So it is tricky, but I think it's worth trying to sort out the trickiness of it, because I think it's it offends the consciousness of right-thinking people that you have gangsters who are responsible for multiple murders in the society benefiting from public contracts. And that is wrong. And until we address that in this country, you know, we're not turning the corner from our ineluctable slide into being a state that is enmeshed in organized crime and corruption. So I personally would have liked us to have found a way to give the court the jurisdiction to do this, and as long as they take into account and make appropriate orders for protecting innocent third parties.
I tend, this is why I pause here, because I see it sounded like with a blanket thing. When I go back to the notes, the committee noted the recommendations and agreed further that the technical legal team would examine the existing legislation, whether the amendment was required rather than creating a new clause, taking into consideration that these may be subsisting, there may be subsisting agreements and subsisting license that had already been procured prior to any conviction.
So we actually had looked at it, but from a slightly different perspective. Doesn't want me to talk. Through the Public Procurement Act. And we realize, well, from our perspective, we think there are some weaknesses or gaps in the Public Procurement Act. So for instance, there is a procedure, I think, after bidding where you could, the weaknesses we perceive are that after you've been awarded a government contract, if there is some issue that comes up about, say, a major shareholder or the director's fitness and propriety, there is no mechanism to then, well, it wouldn't be no withdrawal. If the contract is already in force, how do you end it? As well as, because something could have happened, the person, there could be, you could have passed a fitness propriety test prior to, but then something could have happened afterwards, and it comes to the attention of the, for instance, a ministry. What happens thereafter?
Could I make a suggestion on that? The law on frustration of contracts, the law reform frustrated, there's a statute that if you treat something like this as akin to a frustrating event, then the court is normally given a wide latitude to kind of allocate the risks of that event in a way that seems just. And I think that's the kind of approach I would have recommended that we use.
So, I mean, what we were doing was looking to see what exists even right now with our, because the Public Procurement Act is a relatively new act. So I think the committee could consider making a recommendation here for further consideration or consideration for perhaps amendments to the Public Procurement Act to deal with some of these issues, because in terms of public contracts, contracts from public entities, that would be a good avenue. That would be one of the better legislation, I would think, to address those types of matters, at least to strengthen it from that perspective.
I mean, that act wasn't really focused on law enforcement type, that was more about procurement. So I'm not surprised it doesn't deal with what we're discussing now, which is the underbelly of criminality and its interface with the formal system. But
you see, the thing is, it does, but in a very minimal way, touch on some of these issues, and there would be nothing wrong with it going a little further to say, for instance, who could be precluded in a more detailed way. But you're right, the focus of that legislation wasn't from this perspective. Perhaps maybe we should have looked at it in a different way, but I really do think that that act really could address some of these issues.
I think support of you see, if we need to do something with this aspect of it, and if we're not doing it in this act, we need to state where. If we amend the Anti-Gang Act and we don't deal with this aspect of it, it's not going to look like we're, as parliamentarians, we are committed to really dealing with the issue. So if we're coming back,
I would like to suggest that if something along the lines that if a person is convicted under this legislation, has an interest, a commercial interest, a financial interest in any public contract, including license, concession, permit, whatever, that triggers an obligation on the court to consider making an order treating that contract as frustrated or at an end, and making any consequential orders that may be required in the interest of justice to protect innocent third parties, including financiers who may have financed provided financing on the basis of the contract and so on. Highly necessary, counsel. Highly necessary.
I can see that. I just think it's just something that we need to include. We need to find a way to get it in the courts.
Third-party rights always come up in forfeiture proceedings as an issue. When I say always come up in the legislation, they always need to be provided for, because you can't put the risk
What's the
of
recommended decision? Decision, yeah. We had initially asked for research, and the research looked at in a different direction. What's the recommendation today? Do we ask them now? Do we take a decision to proceed to include such a clause with adequate protection of third-party rights? Well, leaving this as is at this point, to leave this alone, we're going to take some battering for it. Do you know, SG, what you're suggesting?
We can look now from this perspective to see if we can find anything.
See, the reality, the older gangs, the more mature gangsters are moving into legitimate business. That's just the reality today. Many of them are more legitimate business. Of course, reality that's a lot of them get knocked off when they move too far away from illegitimacy. That's part of the challenge. But the truth is, I'd prefer to be able to apprehend them rather than shooting them and adding to the murder rate. So you're suggesting, I didn't want to leave too much to come back to, but you're suggesting, SG, you will take a second look at this with the team, Mr. Bailey.
And just to ask, is it that we're only dealing with if someone has been convicted of an offense under this act? What about if the person has... It's when the person has been convicted.
Yeah.
What about what? You were going to say, what about some other situation?
The Procurement Act to look at people who might be disqualified, but I think we should do something on this anti-gang thing separately.
Minister? Minister, I was contemplating... Oh, I'm sorry, Tanil Beecher, Minister of National Security. I was contemplating how we could perhaps include a clause in our general conditions of contracts for government relating to where a person has been convicted under this act, for that to amount to an act of frustration or a ground for termination. I was thinking about it as an alternative as opposed to trying to find a clause.
There's something not depending if they are convicted already. I think this is investigating the person is convicted when the contract has been just awarded and is in process of being executed. That's what this is looking at. You can know under Procurement Act, if somebody due diligence is done and the person is convicted, they are not qualified, they are removed from the list.
That would be prior to the contract. That would be prior to signing the contract.
Right.
So that would capture that. But what would happen in a situation where at the time of signing the contract all was well, and during the contract the person was charged and convicted under the act? I was thinking about that. So that's how I came up with the recommendation to have a general clause now in our contracts to speak to that. I don't know. That's a suggestion.
Chair, I was just wondering if it might in fact be necessary, because the Proceeds of Crime Act really should cover, yes, because it's any monies arising under those contracts would be a benefit to the convicted person, which would have been forfeited under POCA.
So the court would have to adjudicate that.
You may be right on that.
That's what happens under POCA.
All right, next item here we have is I think we'll leave it as it is then. New provisions including in the Act. Assaulting a police officer in lawful execution of his duties. an increasing event.
Your committee notes the proposal. Your committee notes the proposal from the Office of the DPP on assaulting of a police officer in lawful execution of his duties to incorporate a provision to criminalize the act of preventing an officer from lawful execution of his duties, coupled with the appropriate sanction which would act as an effective deterrent. We note Section 30 of the Constabulary Force Act, which provides for the offense, and further note that the fine was increased to $1 million by a consequential amendment to the Law Reform Zones of Special Operations, Special Security and Community Development Measures Act in 2017. This offense is of general application. Your committee did not accept the recommendation.
Pre-trial detention, that seems to be also. Rejected again.
Because what they're saying is that it's
Minister of Justice.
Pre-charge.
Pre-trial detention was rejected outright.
Your committee notes a proposal from MOCA, the JCF, and the Office of the DPP for pre-charge detention for a period of 7 days, possibly extended to 14 days. Your committee did not accept the recommendation and notes that the issues relating to pre-charge detention were being examined in the revision of the Bail Act and would be revised therein.
Senator, we are recommending 6 months. We can get 1 year? Well, look at the AG's office. This Minister Judge, I would agree.
I'm not the Attorney General.
I would recommend you to SG not to respond to the Minister of Justice. The Minister of Justice wants.
very late. No, we should not have it. No.
I think you have a lot of talent there. I don't know about these things that are assigning. But this Minister of Justice want to give them no pre-trial detention.
No.
We can get 6 months?
6 months what? 6 months what?
Pre-trial detention.
No. It's unconstitutional, Mr. Chairman.
I have a couple of safe houses in Montego Bay where nobody will visit them. I could maybe organize that for some who want to keep.
Unconstitutional. Unconstitutional. Yeah, you were speaking into the mic. Unconstitutional.
And those were very constitutional, I can assure you.
I'm going to.
Come on, continue.
I'll leave this with you then.
Your committee notes a proposal from the JCF for a provision that allows the police to apply for production/inspection orders and account monitoring orders in furtherance of an investigation under the Act. In our deliberations, it was highlighted that the Proceeds of Crime Act would have already made it an offense for bank employees who were in receipt of the production order from law enforcement agency to tip off the customer of the bank. That Section 21(1) and 2 of the Cybercrimes Act provides for production orders, particularly where a device or any information is required, as well as that the order compels the owner to, among other things, provide password, etc., in relation to electronic devices, and an offense is committed where that person fails to comply. It was further highlighted that Section 12 of the Interception of Communications Act and Section 17 of the Financial Investigation Division Act had similar provisions. Your committee did not accept the recommendation, as a request was already provided for in various pieces of legislation, particularly the POCA Act, the Cybercrimes Act, the Interception of Communications Act, and the Financial Investigation Division Act.
Okay, seem to be covered already. Again, raise the issue of getting the information to those who are doing the various investigation and prosecution.
Continue.
Work between DPU officer and the police is helping, so we think we're overcoming this. Mandatory minimum sentence for repeat offenders.
Your committee notes a proposal from the Ministry and MOCA for the inclusion of mandatory minimum sentences to repeat offenders convicted under the legislation. In the deliberations, we raised the issue of dealing with habitual offenders and the mandatory minimum sentences. The things to be reconciled included the high recidivism rate and the provisions for the Criminal Justice Administration Act that dealt with habitual offenders. Your committee did not accept the recommendation.
Good. Next one.
We move on. This Minister of Justice want to give no sentence at all.
All right.
I think we'll have to.
You imputed fake news to the Minister of Justice.
Right, moving
It's
on.
very liberal suggestion from the Minister of Justice. You know, you see. All the work you do and to provide all this, it's been that turned all over. Restitution. I'm sure you accept restitution. We must pay the people back the money. Who they extort from and who they take all the thing from.
Yeah. Your committee notes a proposal from the Ministry and MOCA for inclusion of provisions for restitution similar to what is included in Section 6 of the Trafficking in Persons Act. During our deliberations, we noted that in addition to the law reform, Fraudulent Transaction Special Provisions Act, a provision for restitution had been included in the human trafficking legislation, which were two existing, fairly recently passed pieces of legislation. Nevertheless, we were advised that the Criminal Justice Administration Act 2018 provides generally for restitution, which is to be applied whenever a person has been convicted of any criminal offense. Your committee did not accept the recommendation.
Oh, again, Minister of Justice in the way. I can't understand that. I'm going to ask.
Good sense prevails.
No, I'm going to share the response with the opposition.
What I would love to know, Chairman, is the extent to which the courts are applying
restitution.
The provision that was introduced in the Criminal Justice Administration Act 2018.
I've heard very few instances of it, so, but I will.
I've seen where compensation has been imposed quite a few times.
Yeah.
As a country,
of the person, yes, clearly.
As the country people would say, Mark, when it's the blue moon, you get it. That's real instinct. Okay. Anyway, your colleague just assured me that you have some bright judges there. That's true. No, without being cynical, we'll see how we can get this.
Again, sometimes, like system. That act, which did a number of jurisdictional things to try and make the courts more efficient, training around that is really important. I don't know.
Yeah. It has emerged in this committee quite extensive, and I will certainly read it when we go to Parliament, because that seems to be a critical issue. There's more and more legislation, more amendments, and some people seem not to note their new amendments. This one is one. Cause all kind of problem.
Declaration of a criminal organization. Your committee notes the proposal from the ministry and the JCF for a new provision which formalized the declaration of an organization as a criminal organization. Your committee did not accept the recommendation.
The objection to that, sir, was the fact that in order to make such a declaration, you would have to have established that as a fact by a procedure that had due process and where the standard of proof was a criminal standard. And that being the case, you may as well charge them and try them for the offense under the anti-gang law. It didn't seem that we could have some kind of procedure where a judge in chambers could just make a declaration saying that, this organization or that is a criminal enterprise.
A criminal organization. There's a jurisdiction which is supposed to be fairly similar to ours, which declares drug kingpins long before they go to court. How do you establish that kind of ruling? I think the idea behind this was I didn't draft it, but I suspect there's a kind of thinking behind this proposal.
That's an administrative measure. You say Tom Brown, I think, it's a person of interest.
So that's the same thing. No, but I'm being told we can't use person of interest here. What is the challenge with that? We can, in fact, declare person of interest. And the Minister of Justice will not seek to take me to court on behalf of his constituents who is a person of interest. He has plenty of person of interest, you know. All the white collar person of interest is vote for him. So he has to protect them.
Ah, brother.
Owner, operator, etc. premises used for commission of offences.
Your committee notes a proposal from MOCA for the inclusion in the Act provisions similar to Section 15(5) and Section 15 of the Law Reform Act. 1. Section 5 penalizes the owner, occupier, or persons responsible for the management of premises who knowingly causes or permits said premises to be used for the commission of offences, and 2. Section 15 regarding the fact that an accused is unable to properly account for property which is disproportionate to his known sources of income. Your committee A decided to accept the recommendation to include Section 5 of the Law Reform Act to penalize the owner, occupier, or person responsible for the management of premises who knowingly causes or permits said premises to be used for the commission of offences, and B decided to accept the recommendations regarding Section 15 of the Law Reform Fraudulent Transaction Act regarding an accused being unable to properly account for property which is disproportionate to his known sources of income.
Orders.
Your committee notes a proposal from the Ministry for a new provision regarding the use of control orders on suspected persons, similar to the provision within the Serious and Organized Crime Control Act of South Australia. During the deliberations, it was noted that the recommendations had been included in the schedule to the Law Reform Bill. They were drawn to allow for further consideration and therefore agreed that the Ministry would present these recommendations to the committee. We noted that the Attorney General's Chambers had undertaken research on control orders and there was controversy surrounding their use in England. The United Kingdom has had a history of using control orders as part of their response to terrorism, etc., and the experience had been controversial in terms of legal action taken with cases before the House of Lords and the London Supreme Court. The legislation was not challenged based on compatibility with their human rights regime, but on the specific application of the control orders. It was noted that a control order placed the limits on the free movement or travel of an individual, as well as the ability to communicate freely with others. The United Kingdom has since repealed and replaced sections of the legislation, and the new regime has not been challenged nor used much. It was further noted that the application of a control order regime in Jamaica would pose a challenge, taking into account the application of the Jamaican Charter of Rights. Your committee does not accept the recommendation, but recommends that further work and analysis be done.
On this one, this is the watch list on. Mr. Foster. Administrative. Okay.
No, I mean, I can see the narrative.
Your prime minister is a watch list administrative. Persons of interest.
It has to be done. Right.
This proposal was going beyond watch list or person of interest. Nothing stops an administration from having that. Those are administrative matters. This was going to go above and beyond to allow for legal consequences after you name, after you you do this restriction called this control order, which restricts freedom of movement. It impacts on a number of rights. And remember that England doesn't have a written constitution. As much as they have their UK Human Rights Act, and as much as they are supposed to comply with the European Convention on Human Rights, it's still not the same as our regime. So we again would exercise caution, ask you to exercise caution in proceeding along these lines. And I think legal reform, Mr. Bailey, head of legal reform department, had also pointed out, I think these were measures that were also used in Australia to deal with a certain situation that arose there with biker gangs and so. And recall that Australia does not have a Charter of Rights in their constitution. Their scheme is absolutely completely different than our scheme.
They shoot all the minorities to them come on. All the colonists, and tell us we can't do it, we can't fire our firearms. Is that fair, SG?
I would just point out that since further work and analysis is done, that the Ministry of National Security can continue to work on this matter.
But on the watch list, not on control order. No, it's okay.
Yeah.
Next one.
So no control orders, but we can do an administrative watch list. Is that what they're saying? All right. No, I mean, all right, I'll advise CTD, we keep whatever time we have given out despite our schedule. We take until take a look at this, because given the nature of gangs in Jamaica, you need to have some mechanism of really monitoring the gang leaders on an ongoing basis. A legal mechanism. Besides intelligence and CIB, you need to be, I mean, you get asked every day, you know everybody, you know every gangster, you know everybody who commits a murder, yet you can't arrest them. You can't follow them, you can't, I mean.
You can only do it after you charge them. Once you've charged them, you can control their movements, but not before.
Getting evidence.
Well, that's
and getting the evidence means they kill some people before they get the evidence in court.
Chicken and egg. Go ahead, Terence.
Your lawyers need to find a mechanism.
Right,
the one time my distinguished lawyer. Find me a solution, you know, when they're not here. Okay, use of unexplained wealth orders.
Your committee notes a proposal from the Ministry for the inclusion of provisions for the issuance of unexplained wealth orders on suspected individuals. Your committee does not accept the recommendation and notes that the matter is to be reviewed in relation to the Proceeds of Crime Act.
Yeah, we'll examine it later.
Your committee notes a proposal from the Ministry to establish and maintain an organized criminal registry or watch list for persons charged with or convicted of offenses under the Act. Your committee does not accept the recommendation, but recommended that with the support of Legal Reform Department, there was need to bring the work of examining the existing pieces of legislation that deal with a range of matters forward. These include how ex-convicts are dealt with during the period of rehabilitation when they continue to be threats to the society, and the methods of monitoring these persons, how persons are dealt with between the stages of being suspected of committing an offense and being charged with an offense, the stage after charge and prior to conviction, and examination of the requirements across all the areas of monitoring and what may be required specific to certain types of conduct.
To examine, did we come to any solution on this?
No, but nothing wrong with that.
What are we doing
just
here?
An administrative thing. You have to pursue it administratively.
So, Bullet point 2, how persons are dealt with between stages of being suspected of committing an offense and being charged with an offense.
That is the
And the stage after
pre-charge.
charge prior to
That's what
conviction.
you're looking once again there in the pre-charge, which is what we're looking at in terms of the pre-charge bail, which is still under consideration. So, no, not at this time. Not in this legislation.
Your committee notes a proposal from the Office of the DPP to amend the first schedule of the Act to include offenses relating to simple larceny and receiving stolen goods. It was noted that the intention was never to bring collective criminal conduct of a relatively minor nature within the scope of the Act, as the penalties were potentially severe and the trial procedures take into account the nature of organized crime. This is the reason the term serious offense was defined in the Act to refer to an itemized list of serious offenses in the schedule. However, your committee carefully considered the issues affecting the successful prosecution of gangs gangs involved in a variety of criminal activities, including that what can be viewed as not very serious offenses. Based on the narrative on the prosecution of gang-related cases, it was indicated that gang activities included a range of criminal activities, including the stealing of goats, and that criminal organizations benefit from the proceeds of the criminal activities. We note that amendments to the listing in the schedule could be addressed by the minister responsible for national security, but further note that the Act covered offenses that were generally regarded as serious offenses. A suggestion was made to amend the Act to refer to applicable offenses instead of serious offenses, which would allow for a variety of offenses to be listed in the schedule, including simple larceny and receiving stolen goods. Your committee agreed to accept this proposal.
All right. Acknowledgements. Your committee wishes to express sincere gratitude to all those individuals and organizations made written submissions and oral presentation or participate in deliberation. Do we write them?
No, sir.
Just make note of it publicly. The committee wishes to thank the Ministry, the Jamaica Constabulary Force, MOCA, Office of DPP, Norman Mandela School for their submissions and for participating in deliberations. Special recognition is extended to the staff of the Office of Parliamentary Counsel, the Attorney General Department, and the Legal Reform Department for the technical guidance throughout the deliberations. May I express my thanks, one. The committee is grateful to the media who were able to cover the meetings and report the proceedings to the public, the clerk, the host, and her staff, and a special thanks for the invaluable assistance and kind courtesy extended during the meetings. And while they're only doing their duties, I must commend the member from South St. Daniel, Senator Karen Morrison, who are the backbone of these committee meetings. All right, thank you. All right.
Chairman,
The
just
Minister of Justice.
a quick issue about the appendix.
I was saying,
the
procedure from
list
here now.
of
We may have to
amendments.
have one on the meeting for a short time.
So, aren't there a list of amendments?
There,
A list of amendments.
I'll have to.
Judith, right?
How do you? That's why I'm asking the procedure from here. The end of it.
because normally
What we just
those-
went through are the new provisions to be added from page.
No, I know. No, Chairman, what I'm pointing out though is there will be a list of amendments that normally we would append to the report. So the committee really should, I know Ms. Grant will have to now do some work because she had to wait for the committee to finalize the
Ms. Grant is always
report.
working hard.
She
Ms.
does,
Grant is
above
saying
and
like
beyond.
You need work.
But should have to tailor it to, so that it is consistent with the decisions of the committee. But
Right.
I'm just suggesting that once it's finalized by CPC, that if it's sent to committee clerk, that it be circulated so at least the members can comment on
Right.
it before they actually sign the report. Just a suggestion.
All right, what's the procedure from here now to get this back in the house? Can I give me it's a new? After we, what's that? Oh, sorry. one more meeting from what I...
Maybe one or two, sir, because the one to go over everything.
Okay,
And possibly, I don't know if we'd have time to sign it, hopefully.
okay. We'll try for it. The best days for meeting was Wednesday, right? That's when we got our best attendance.
Yes, sir. So far
So you lock up
with
2 Wednesdays in January. Or they look them already?
so far they're filling up, so we could say the dates from now.
All right, colleagues, before we go, and I have the appropriate thank you, I'm suggesting we're going to block another Tuesday morning in January, the 21st, and the 21st. It's not taken up by the CDF yet. Yes, we expect, that's why I said the 21st, not for the 21st, circulate everything. The BOJ and number of other financial that are racing against the criminal side to have the thing. The Joint Select Committee, we are restricted in this parliament, too restricted. Yeah. So I'm going to suggest that if we cannot conclude in that one meeting, we should need one more meeting. If necessary, we take a small conference room at the conference center the following week or 2 weeks from then. Even if we have to pay for it from our ministry. Mr. Richards, I'll come at the pace, but we need to ensure we get this thing done in January. All right? Adjourn then until, can I wish for everyone a happy and healthy and peaceful Christmas. You all worked hard this year, and it looks like the work continues, but we hope we can find some peace and quiet in the holidays. I'll try my best to make sure, I will try and make it as safe as possible from my side and peaceful as possible. Speak on behalf of the Commissioner. Thank you very much.
Cha la 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 la. Bim. Cha la 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 la. Cause a long time we are rocky Tina down. Me say a long time we are skanky Tina down. Long time we are flashy Tina down. Me say a long time we are skanky.
This is Empress Sativa representing for PBCJ.